Couchman, please state your name.
Maurice Couchman.
Okay.
Teresa Claire on behalf of probation. Your Honor, it's my understanding that the victim in this case, Alyssa Chamberlain, should be present via Zoom.
Alyssa.
Yeah, I'm here.
Okay. Yes, she's here.
So, Your Honor, it's my understanding that Ms. Chamberlain would like to address the court to request the court lifting the contact order. Does the court want to address that first, or my recommendation for Mr. Couchman?
Either way, go ahead with you.
Okay, so as to Mr. Couchman's, is compliant with the terms ordered by the court. I did make his appearance, however, he is present today. Probation is recommending that all conditions continue as previously ordered, with the next review hearing being set February 10th, 2025 at 1 p.m.
Sir, anything you want to say?
I know she wants to take the order away or whatever. I want to keep it.
Okay, so hold on. Ms. Chamberlain?
Yes, sir.
All right, do you have a camera?
Yeah, you want me to turn it on?
Yes.
Okay. Hello.
Hello.
Hi.
All right. What did you want to tell me?
I just wanted it lifted because I've been in contact with his mom to see our son Leo, and she hasn't really been compliant with it.
You've been in contact with whom?
With Maurice's mom.
Okay.
And she hasn't really stuck to her things or anything like that. The last time I was supposed to pick Leo up, she completely ghosted me. So I was just hoping to maybe lift the no contact order to just talk to Maurice directly, but just about our son.
Okay. And thank you. And you have a problem with that?
Yes, sir. Yes,
All right. Hang on before you go.
People would be opposed to any change in the no contact order this time.
All right.
It's my understanding from probation that probation, I don't know if you're taking a position or not, but people wouldn't be opposed to it.
All right. Sir, what did you want to tell me?
I just want to keep it like it is, no contact.
You want to keep the no contact in place?
Yes, Your Honor, because I don't know if you were been told, but there was an incident a couple weeks ago. Her and her mother came to my house, and basically how I have it set up is my mom is supposed to make contact with her, and the last time she tried to make contact, she said she was going to pick the kid up at 4. She never picked my son up. She just ignored my mom. Alyssa Chamberlain.
Okay.
So,
go ahead.
she came to my house.
Who did? When you
Alyssa
keep
Chamberlain.
saying she,
sorry,
I'm just trying
sorry.
to. It's okay.
Alyssa Chamberlain is just
Right.
backing. Alyssa Chamberlain came to my house with her mother with the no contact. She's not supposed to be around me. I told her that. I called the police and made a police report. There's no reason for her to talk.
Okay. So hold on a second. So, because I just want to make sure I understand. The arrangement was set up that your mother would act as a go-between, basically.
Yes,
Is that right?
yes.
Okay. And then for whatever reason, something happened where you're claiming Ms. Chamberlain did not get the child from your mother. Is that right?
Yep.
And then 2 weeks ago, you're saying thereabouts,
Yeah.
that Ms. Chamberlain and her mother
Yes.
show up at your house,
Yes, Your Honor.
and that you ended up calling the police.
Yes, Your Honor.
Ms. Chamberlain, is all of that correct?
So kind of, it was me and my aunt, and we did show up at his mom's house. But at this point, I didn't know that me and Maurice had a no contact order. I wasn't aware of any of this. I moved and didn't receive any paperwork. I changed my number, so I wasn't receiving any calls or anything. So what happened
What do
was,
you mean? What do you mean that you didn't know?
I didn't know there was a no contact order.
So
I didn't even know Maurice got
why
in
do you-
trouble.
Hold on. So why do you think you were why was his mother then acting as a go-between?
I just thought he didn't want to talk to me.
Okay. So it sounds like he still doesn't want to.
That's okay, but we need to figure something out to where his mom answers the phone and sticks to her stuff when I'm supposed to pick our son up.
Okay, so I'm going to assume that the mom, his mom,
Yes, sir.
I take care of,
is,
I
hold
take-
on, hold on. That she's a full-grown woman, and so are you, right?
Yes.
So it seems like for your son or grandchild, that the two of you could talk to try to work out whatever you guys want to work, and that Maurice doesn't necessarily have to be a part of that, does he?
I mean, no, and it wasn't a problem until the last time when I was trying to get Leo. She told me I could get him, and I confirmed it the day before and then completely ignored me. So then that's when me and my aunt went to her house to try to talk to her. I didn't know Maurice
Right.
lived there.
Okay. So here's what I'm gonna do, because there's obviously something else. I'm not entirely clear what's going on, but if he got into a circumstance where he had to call the police, then that circumstance can't happen. So I don't know what is going on, and you guys as parents need to figure this out for your son, quite frankly. But as between the two of you, if he doesn't want to have contact, I'm not gonna force him to have contact. I mean, he's relying upon the court's order, and he did, quite frankly, given the other hearing I had today, he did exactly what he was supposed to do when you showed up.
Right.
He wasn't trying to do anything. He called the police because he's the one under the jurisdiction of the court. But if he doesn't want that, I'm not going to change anything.
Okay.
And for the record, Your Honor, I asked probation if there was currently a circuit court order regarding parenting, and there is not. And the defendant has custody of the child this time.
Who does?
The defendant.
You have custody.
Yes.
I do not have like
Hold
legal
on.
custody, but I've been taking care of my son for the last 8 months, taking him back and forth to school, everything.
Okay.
So.
I'm
Now
just
you're
being.
giving-
No, I got you. I
Now
got
you're
you.
given legal advice about what to do, but.
Well,
There's no
somebody's
circuit
going to have to figure. Yeah, you guys are going to have to figure something else out. But, ma'am, Mr. Couchman does not want contact with you directly. So I'm not going to place him in a position where he has to do that, because obviously he's maybe through this process learned something. So I'm just going to leave everything where it is. I'll continue all of your, Scotsman, I'll continue all of your previous terms as ordered. I'll set your next review hearing for February 10th, 2025 at 1 p.m.
Thank you.
Okay, thank you.
Hey everybody, welcome to American Courts. That's a good question you got there, Nancy. Is what happened to the judge this morning? I do not know. At 10 o'clock my time, which is 9 o'clock the judge's time, I was logging in, waiting for it to come live, and it never went live. So I have no clue what happened. I don't have any insight. I was hoping I'd figure it out later in the day, but it just nothing ever came through. And so, no one got banned. No one got banned in Judge Fleischer's court today. I don't know. I can speculate. I can come up with all kinds of stories of maybe he knew it'd be too rough after the election, or maybe he just didn't like the comments or something. But there's no sign or anything that he did any court today at all. So I don't know. I didn't ask. I don't ask Victoria questions like that because I don't want her to put her in a spot. She's super kind to us and super nice to us, and I don't want to put her in a position where she doesn't have an answer that she wants to give. Hey KK, it's good to see you here. My brother LD was in the chat. That's exciting. My brother's LD Henderson, so it's great to see whenever he comes around. And there Emily smiles. That's my wife. So I get to see everybody. And Lena said he took the day off. Okay. And see, there you go. Me and Linus are pretty close, and I didn't even ask her. So I just, in the end, I don't even, I don't ask things I don't need to know the answer to, and a lot of those things I don't need the answer to. I was one of those guys at work. Whenever someone would call out sick, I wouldn't ask them why, what's wrong, or any of that. I just assumed if they're an adult and they called out, they called out. So why ask them? But we've got some good court tonight. A lot of Judge Middleton. I really like Judge Middleton. He had some interesting cases. Probably about a month ago, he had a guy in there that was taking his clothes off in there and just kind of acting crazy, and they had to do a competency exam on him. Well, they got the follow up for the competency exam, so I'm going to play that. There's a little bit. It's a little slow at the beginning because it's Judge Middleton, but it picks up and it gives you more to the story about it. Let's jump into the competency. It's not too long, and it's interesting in there. So
this is a hearing regarding the competency of the defendant in file number 24903 FY, People versus James Charles Jude. Mr. Jude is charged with a felony home invasion charge and a charge of malicious destruction of personal property over $200 but less than $1,000. He was arrested in May of 2024, and we've yet to even conduct a preliminary examination in this matter. The defendant is here with his lawyer, Rhonda Ives. Prosecuting attorney is represented by attorney Andrew Rogness. Early in the process, the court and counsel asked for a competency evaluation, and that took a while. And there was a competency evaluation conducted by a doctor from the Center for Forensic Psychiatry. Let's see if I can get back into it. We received that report on August 16th from, get to the bottom signature line, Carissa Carlson, a consulting forensic examiner. And the opinion was not exactly a rousing finding of competency. The parties present, I think it was Mr. Robert and Ms. Ives, stipulated to the report. I'll read the opinion. I was unable to thoroughly assess Mr. Jude's mental condition at the time of the present examination due to his declining to participate in the evaluation. Because of this, I was also unable to directly ask him questions to assess his understanding of the nature and object of the proceedings against him, or assess his inability to rationally assist in his defense, his ability to rationally assist in his defense. An opinion on the competency is required. Good morning, Mr. Bland.
Good morning, Judge.
Regardless of the level of participation of Mr. Jude, at the time of the instant evaluation, he was reportedly refusing all psychiatric medication. He was noted by jail staff to, quote, have something wrong with him, end quote, but it also indicated he knows it and sometimes he uses it, end quote. In my opinion, due to the limitation of not being able to directly evaluate Mr. Jude myself, and my understanding of the statute, one has to opine that the presumption of competency. So essentially, because she couldn't connect with him, she's found an opinion of competency. Although the ultimate decision on this matter rests on a judicial determination, it is my opinion that Mr. Jude is competent to stand trial if he so chooses. And I indicate that was in August. We had a hearing on that matter, and Ms. Ives requested a continued independent forensic evaluation. So I did not make a finding of competency or not competency. She obtained a second report, and the court received that. I'm not sure. It was submitted on October 14th. We had some difficulty scheduling this hearing because Miss Ives was busy with a lot of other matters, but we settled on this morning. So that report was submitted by
Dr. Farhat.
Let me get to the bottom here. Sami, S-A-M-I, Farhat, PhD, licensed forensic psychologist. He's the owner of Foren Psych Evaluations. Mr. Agnes, on behalf of the state, may we stipulate that I may consider that report?
Yes, sir, Your Honor.
Ms. Ives, on behalf of your client, may I consider that report?
Yes, Your Honor.
Mr. Jude, I haven't seen you in quite some time, since last spring, probably. Dr. Farhat had a different conclusion than the doctor from the forensic center. One of the questions, the doctor from the forensic centers said you could be competent and assist if you choose to. So there's a concern about whether this is all an act or whether you were suffering from mental illness. And Dr. Farhat says, primary opposition to my opinion was that Mr. Jude was either malingering or simply being uncooperative. The reader may reasonably consider whether his non-compliance and disruptive behaviors in jail and lack of engagement were volitional in nature. Some behaviors may occur in those attempting to feign or portray themselves as mentally ill. I have in fact evaluated many defendants who are malingering. The strategy involved flooding their cells and other things. Based on this information, I considered whether his non-compliance and disruptive behaviors were the result of feigning or volitional uncooperativeness. Dr. Farhat finds that presently you're incompetent and you could benefit from further hospitalization and treatment. And he says there were several factors that led to me to that opinion. First, Mr. Jude has adamantly denied having anything wrong with him throughout his incarceration. He informed me he was not crazy and did not require psychotropic medications. Similarly, Mr. Carlson stated that he lost his shit when offered medications at the jail. This would be a counterintuitive malingering strategy, as malingering involves an attempt to portray themselves as mentally ill, or this defendant is denying his mental illness. The doctor also believes that there is substantial likelihood that Mr. Jude will attain competence if he's provided with a course of treatment within the allotted time. Some psychotic individuals are resistant to treatment and will never be restored to a state of competency. I considered whether Mr. Jude was such an individual. As I stated above, the vast majority of psychotic defendants are successfully restored when treated. I'm unaware of any information suggesting that Mr. Jude was in treatment, resistant to treatment, would not respond to treatment efforts. As such, my opinion weighed primarily on what is statistically known about the restoration of psychotic defendants. That he will be more likely than not to be someone who could be successfully restored to competence. Mr. Jude, you're stuck in a legal limbo. Your brother is here because he's interested in this. We haven't even really got the case started. The conduct that led to your arrest was bizarre, somewhat, and irrational. You were painting on the house and other things. You were uncooperative really from the get-go at the jail. And so we aren't even in a position where we can discuss a plea offer. such as reducing this to a misdemeanor or that sort of thing, because of the concern as to whether you're competent to assist in your own defense.
Got me in here for a $50 window.
Yes.
Yeah.
So the Center for Forensic Psychiatry said, well, we don't know. He's not cooperating, so we find he's competent. Dr. Farhat's opinion is that you're not faking or malingering or manufacturing this mental illness, that you have a mental illness that you don't want to address. Mr. Rognus, you have anything further on behalf of the people?
Your Honor, reviewing Dr. Farhat's report, it's obvious that Mr. Jude is not cooperating with Dr. Farhat. I find it inconceivable he's going to cooperate with defense counsel unless he gets his current circumstances remedied by whatever's appropriate in these circumstances. It may be a course of medication or something similar, but
I'm not taking no medication.
I tend to suspect that what Dr. Farhat indicates is accurate.
His eyes, you wish to speak to this?
Well, thank you, Your Honor. Well, again, in meeting with my client, he noted that he is being poisoned still. He said that his hair is falling out and that they're poisoning him, and that's the reason why he's lost so much weight. I mean, it's difficult for me to comprehend. I do not believe for 1 minute that the jail is intentionally poisoning him. But that is his belief at this point. I would indicate that it's been very difficult for me to meet with him, because just looking back on my file folder, my very first attempt to meet with him on May 30th, he refused to meet with me. Then on 6/4, back on June 4th, we had I think that was one of the initial court hearing days. At that point, he did talk to me, but he was defensive. He made statements that the victim was not his father. I think I understand it's his stepfather. His statements didn't make any sense as it related to the report. And then again, when I tried to visit him later in June, he refused contact with me. And discussing with his brother, what I think is interesting to note, that his brother described behaviors that he noticed, that he was covering up his microwave, his phone, taping up his vents, which is very similar to the behavior that he's doing in the jail. And this was going on prior to his arrest. So I believe something is going on with Mr. Jude that he needs help for. And I mean, I don't know what that is, but I believe Dr. Farhat is probably closer to understanding it than any of us. Thank you.
I read both reports again yesterday and again this morning, and Dr. Farhat's report is very well informed. And the Forensic Center made a finding of competency, I think, because they didn't know what else to do. I find, based on this evidence of both reports, the defendant is presently incompetent to stand trial, but restorable. There is a substantial probability that the defendant is provided with a course of treatment. He will retain competence to proceed further, including trial. So I've signed an order to that effect. Mr. Jude, we need to get this case moving. You're stuck there in a cell. You don't like it. You're right. This had to do with the destruction of your parents' home. It's the kind of thing that could be resolved if we could get to a finding that you're competent. So I'm going to take you back to the jail. You are going to be taken to the State Center for Forensic Psychiatry for further evaluation and treatment, hopefully with the idea that you can be restored to competence. All right, you can go with the officer. Thank you for being here, sir.
So all this for a $50 window
Yes, sir.
that you can't prove?
Well, I don't know about that, but we can't even get to first base yet. Thank you.
So this guy here he broke into I think he broke into his parents' house or his stepdad's house and broke the window. And the last time he was in the jail, he was I think they said he was like doing a starvation protest, and he started taking off his clothes, saying how he was being mistreated in there. And so whenever they try to give him the medicine, he freaks out and acts out because he thinks they're trying to poison him. Now, one psychiatrist took a look at him and said that they don't think he's mentally ill. They think he's faking it. And so the defense lawyer got another one, and the second one said that he is mentally ill, but with the right amount of treatment, he can get back to normal. And so, like he said, all over a $50 window, it seems he hasn't even been able to get to the probable cause hearing. So he's been in jail a lot longer than if he would have just, claimed guilty and just run it through. So something's definitely wrong with him because he's staying in jail an extra long amount of time. So something's obviously wrong with him. But he's going there. Thank you guys for all the comments. It takes me a long time to read through them. I'm not that quick, but I'm getting there. We're doing better. We're going to jump over to let's jump over to Judge Webster from the other day. Jared Regier got in trouble from her, so here we go with that one.
State of Kansas versus Dallas, Kirkham, Sawyer. Please announce appearances.
Jared Regier from the state, Your Honor. Peter Hagan for Dallas Sawyer, who appears with me.
And how does your client wish to proceed, Mr. Hagan, on this one count of voting under the influence?
Well, Your Honor, this case has been going on for about a year.
Yes.
We still have yet to get the blood results. And we've been asking for those, and you ordered them probably the last 2 times we've been in court, and I still don't have them. My office calls, they said they've provided all the reports. And so here we are. I mean, I should make an oral motion, to dismiss this case based upon the time that this case has been going and the lack of blood results.
Mr. Regier, your response, and I know this probably isn't your case, but you're on the spot with it today.
Yes, Your Honor. This is a case where it is the state's understanding that blood draw reports and KBI lab reports were involved in this matter. I have communicated with my colleagues. It is the state's understanding that counsel for the defense's office communicated with my office back in March, and that at around that same time, both the blood draw results and the KBI lab reports were provided pursuant to standard discovery procedures, and all discovery has been provided in this case.
Well, even if that is the case, why in the world, since March, could you not have given him another set? I mean, that to me just seems like a obvious solution to this. If whether he has them, whether you sent him or not, he's saying, I don't have them, I need them.
I received all the reports, Your Honor, and there weren't any blood tests in what I received. And we've been asking for this, and they said they'd provide them.
Right. And I know people are human, and it may have accidentally been left out and not, someone didn't realize it.
And Your Honor, I did
put in there, and Mr. Hagan's staff misplaced it. I don't know, but he needs those reports. He's been asking them since, I don't know, April, June, again on August, now in November. Why can we not just give him another copy, Mr. Regier, if you know the answer to that?
Your Honor, I did communicate with my colleagues regarding that this morning, and it is the state's understanding that an additional and that my office did make those available again this morning. So
all they need to do is send me the lab.
That's all they need to do, and I've told you to do that. I've told your office. And I suspect, Mr. Regier, that you've put notes in your file telling people to do that, and I just don't understand why it's still an issue. Well, Mr. Regier, is this Mr. Sweeney's case? Is it Mr. Canfield's now, or is it yours?
Your Honor, it would appear that unamended information was filed in this case. My name does appear to be on it. If counsel for the defense will communicate with me directly. Perhaps that will enable a timely resolution to be reached in this matter.
Okay, so they put you on the case, had you filed the amended information, or I shouldn't say they had you. You filed the amended information January 30th of 2024. And it does have your name on it. And I understand.
All right, I'm gonna go ahead and pause it there for a second. I think something just happened. I think my channel got monetized again. I'm not sure. Hey, Kimby, how are you doing? Thank you, Kim, for a super chat. That's pretty awesome. So, Kim, let me mention something to you. I've got 167,000 subscribers on this channel, and yours the first super chat. So that's amazing. That's awesome. That's such a weird thing. This case is quite interesting. This, you know, the defense attorneys wanting the blood work from boating while intoxicated, and you know the prosecutor just didn't send it over, and it's been going on. March was the last time that they were trying to get it, and so it's just going on. And I get what you're saying, Bodie. I get she has a different voice, so I get that. But this is a really interesting case, and I think it's certainly worth it. Hey, Betty, how are you doing? Hadn't seen you in a while. Betty. Hey, Maiko, good to see you over here. Got Kimby, ATX Alley, Terry, Nancy, Rivette. Yeah, Rivette, you also sent Rivette sent a video for the Court Addict with ATX Alley. It's coming up at 9 o'clock. I've got to think about that one, Rivette. That one is a little explicit, and I just got to make sure it's okay for YouTube, but I don't know that it's okay for me. I'm kind of a wimp, so let's think about it and check it out. But I'll talk about it with Allie, and we'll see what we'll do with it. If we can play it, we will play it. I just don't want to. In the end, I just gotta be careful. It's just the lady had some crazy moments, and so. But we're gonna jump back into this one because I got a lot more court, and we got to get over to Court Addict at 9 p.m.
In this business, the prosecutor doesn't personally put the paper in an envelope and mail it or fax it or whatever, but unfortunately the attorney is the one where the buck stops. So your staff is telling you they sent it in March. You don't have any indication that they tried to send another one after I ordered them to several times?
One moment, Your Honor. Your Honor, in reviewing my notes, it would appear that I did request my staff to review this back on August 19th, and it was confirmed that the reports were provided. I also have a note in my file which would appear to indicate that the reports were successfully received by counsel for the defense's office on March 12th of this year at approximately 10:26 a.m.
And how do your notes confirm that?
In communications with my staff, Your Honor, as well as a certain ledger concerning the issue of discovery.
All right, but you don't have anything confirming from Mr. Hagen's end that he received those? Just that
Your Honor, it would appear that there is a note in my file which would appear to indicate that an email was sent out concerning the issue of discovery to counsel for the defense's office on March 12, and it was confirmed by the individual from counsel for the defense's office that the email was received.
Mr. Hagen, do you have a response to that?
Sure, Your Honor. What I received March 12th were all the reports that I know of from them, and they did not have a blood test with them. Every time we've been back to court, I've said that. And my office called and said, send the reports. They said, we've already sent them all, just like he's telling me again. And so here we are, how many months later, and all I've asked for is the lab results, and I don't have them to this date. And every time we've been to court, that's all we talked about. He said he would send them that day last time and the time before. So I'm confused.
I am too. I know both attorneys are officers of the court, and you're both very credible, responsible attorneys. And so I'm in a very difficult position, not knowing what to think, because I know that Mr. Regier is very diligent. I know that you are as well, Mr. Hagan. My suspicion, if I had to just come up with without saying someone's just not being truthful, which I don't think that's the situation at all.
No, I don't think that he's anything other than we've asked for him and I haven't got him.
That's the troubling part. And that's saying, well, we sent them back in March is not satisfactory to this court. Every time I tell you to send them, I expect them to be sent, and not this, well, we've already sent them, we're not going to do it again. That is totally unacceptable. This is the defendant's right to this information. It is the defendant's entitlement to see the evidence against him, to question it, to examine it. And he is being denied the right, whether his attorney lost the documents, whether the county attorney's office in good faith thought they included them in that email, but left them out. They've been told multiple times, get them there. So it's been about 210 days-ish, approximately, since first appearance in this case. And counsel, why should I not just dismiss it right now? Because I have told the county attorney's office multiple hearings now over the course of months to send him those blood reports. If he's got them, so be it. Send them again. Do you have a good answer on that, Mr. Regier? And I know you're in a tough spot here, but the buck's—
Your Honor, if that is the court's order, and if the court is prepared to take a brief recess in this matter, I can communicate with my staff regarding this issue immediately.
Would you do that, please? I know
Certainly.
we've got a lot of hearings to cover today, but I know this is a big issue. 0.15 while voting, that's a big issue. So if you would, Mr. Regier, I'll certainly give you time to come up with that.
Thank you, Your Honor. And if the court is prepared to go into a recess, it looks like Mr. Patterson is back on this docket. So I'm not sure what the court wants to do as far as that is concerned.
Well, do we have another prosecutor?
I believe Mr. Canfield is on the Zoom.
Okay, I didn't see Mr. Canfield. Yeah, you take your time to figure that out. So, because I want to try to get this figured out today, so we don't just keep coming back for another year.
Very good, Your Honor.
Thank you. All parties appearing as before. I believe I posed at least a rhetorical question to you, Mr. Regier, as to why I shouldn't dismiss this case based on its history and certain facts. And Mr. Regier, have you a response at this time?
Your Honor, again, the state's understanding is that discovery was previously provided in this case. I have had communicated with my office further regarding this matter, and it is the state's understanding that the requested information has been provided to counsel for the defense, and counsel for the defense has confirmed receipt of the same.
Okay. Mr. Hagan, you didn't ask to have it dismissed. You brought up that you could or might or should, but what's your position?
Well, my position, Your Honor, is he tells me that they sent this in April. In June 17th at court, you ordered them to provide me the reports. June 17th of this year. Then we were back on August 19th. I still didn't have it. They said they would provide it. They still haven't provided it. And I don't know how he's trying to stand on what he sent me in April or whatever, because, you know, we've been to court several times. He's been ordered to do it. They said they would do it that day. And now he's trying to say, well, we already sent it, so that doesn't count. Under the statute, Your Honor, he has 180 days, and we're past the 180 days. And I don't see any excuse for him not to have provided it to me by now. So I'm requesting that the case be dismissed, Your Honor.
Mr. Regier, do you have that document in front of you?
I do, Your Honor.
Would it not have just taken a couple of seconds for the county attorney's office to fax or email that again to Mr. Hagan?
Your Honor, unfortunately, I would need the opportunity to discuss that issue with my colleagues further.
I think it's a common sense answer. You know, I could say that, yes, the county attorney sent it in March or April, and that Mr. Hagan just lost it. The worst possible scenario, Mr. Hagan is, you know, I hate to even say or suggest that remote possibility that he's just using that as a stalling technique. But you can't even do that when I keep telling the ordering that the report be sent every 2 months. If you were telling me, yeah, we sent it every 2 months, every time you ordered it, Judge, then Mr. Hagan would kind of start looking suspicious that he either wasn't running a very efficient practice or that he was in the habit of losing things or worser issues. But now this defendant is entitled to a speedy trial. And I don't see that he's been given the speedy trial. And because I have ordered multiple times that that the alcohol and drug evaluation be turned over to the defendant, and it has only been allegedly turned over once back before I ordered it.
And Your Honor,
Mr. Regier?
It is also the state's understanding that the request information has been provided to counsel via email, and I believe Your Honor may have been included on that same email as of this
Saying
morning.
An email of what date?
This morning at approximately 9:37 a.m., Your Honor.
Well, Mr. Hagan, have you seen a 9? Well, that's after the hearing started.
I've been on Zoom. I've been on Zoom since 9 o'clock this morning. If
So
he
have
sent
I.
it this morning, I may have well received it, but I haven't looked for that, Your Honor. That seems to be quite late to.
Yeah, I'm not going to take the time to look at that. We've already used far more time on this case than what it should have taken. I'm very, very troubled at the thought of just summarily dismissing this without hearing the evidence. But I also have to recognize the defendant's right to a speedy trial. I'm going to hold this in abeyance before I make a decision on it. I want to do a little bit of pondering and reviewing speedy trial and so forth. Jen, do we have any time on a 1:30 before? Well, Mr. Hagan, are you available on 1:30 Wednesdays?
Which Wednesday?
Well, I don't know which Wednesday. I just want to make sure you didn't have something that kept you tied up every Wednesday.
No, I don't have it every Wednesday afternoon.
Okay. Jen, let's see if Jen can squeeze this in for
that's
review.
actually
So
a
I
good
can-
day for me. So
How soon are you wanting it, Judge?
Oh, what do you have, about 2 weeks maybe? Would that be workable?
I've got a good opening on the 20th of this month.
that's fine.
How about November 20th at 1:30, Mr. Regier?
No objection to that date at this time, Your Honor.
All right, so I will meet with you all again, client, Mr. Sawyer as well, on that date and time, November 20th at 1:30 to render a decision on what to do about this. In the meantime, Mr. Regier, what the heck? I'm going to order it again. Send him the report and see if there's any chance that you could talk your staff into getting it to him.
I will put it on the file, Your Honor.
All right, and I'm just talking about the alcohol and drug evaluation, that's all. He seems to have everything else. All right,
Very good, Your Honor.
thank you.
Seems like there should be a time limit on it. If you get arrested for DUI and they can't show up with the blood work or labs or something in let's say a year, they should just let you go. I think 90 days is good, but you see in Judge Fleischer's court where they're talking about labs taking 6 months. To me, any state that's taking that long, they've got to figure it out and they've got to start. If you've got to outsource it, you got to outsource it. As much as you have to, but imagine being innocent of that. Imagine knowing that you drank one drink, and they got you for boating while intoxicated, and then you got to wait a year or fight it for a year. You got a private attorney. You're paying that attorney for a year. Now this guy here, he was like 0.16, so he was plenty drunk enough. But if he has to play by the rules, so do the police. So we're gonna that. Allie had to go to Taco Bell, I guess. Sam's Club. She had to go to Taco Bell. She didn't go to Sam's Club. All right, we're gonna jump into a civil one with Judge Middleton, where they're trying to argue about some rent. So it's kind of a landlord one, but it's kind of a judgment that it's already over with the landlord-tenant side of it. So here we go with that.
Mr. Barton, in the complaint, at the very end of it, there is an accounting sheet that shows how they calculated this figure. Did you see that?
No, I didn't see that paper at
Yes.
all.
Well, you did, if it's in there with the packet. So it takes me a minute to find it because I have to scroll all the way to the bottom. There's the lease with your signature and initials all over it. There's an addendum regarding community policies. There's an addendum regarding parking. There's an addendum regarding drug use. There's an addendum regarding pets. There's an addendum regarding, and your signature appears on every one of those. But at the very last part of this, within the last few pages, don't know why I can't, is something called a move out statement dated 12/30 of 22. And you should look at that and study it. It was a lease from 11/1 of 20 to 10/31 of 21. Move-in date 4/23 of 20. Move out date 8/25 of 22 is what they claim. And they show a beginning balance as of August 1st of $6,658. And that would be, give or take, $2,100 a month. Then there's trash charges, sewer charges, stormwater charges, renter's insurance, CAM assessment, a bunch of things that I'm not familiar with here. So you should look at that. That is how they came up with the figure that they used. If you scroll all the way to the bottom, there's an affidavit by an authorized representative. So you need to look at that because we're going to be discussing that at a pretrial conference. Plaintiff may also choose to file what's called a motion for summary disposition. But at this point, I will grant your motion to set aside the default and I will set the matter for a pretrial.
Judge, if you don't mind, Mr. Barton, do you have something to write with? Or can you give me your phone number to reach you? Is that
Well,
okay?
here,
if I give you a
I'll
call?
tell you what, I'll put you in the breakout room and you guys can discuss it with each other briefly, okay?
Perfect, thank you.
All right, Mr. Barton, I'm gonna let you talk privately with the attorney for the company. And then you guys can exchange information so you can talk with each other prior to the pretrial date. I don't yet know when that date is. The clerk's gonna have to set it. Are you still at the Thomas Road address in White Pigeon?
Yes, I'm still living there with my aunt.
All right, very good. All right, you click on the button that says join and you can talk privately with Mr. Werber about exchanging information.
Perfect, and we won't come back, Judge.
All right, very good. If you need anything, I'll be here.
Okay. Appreciate
All
your
right,
time and I apologize again for that.
It happens sometimes. Tell Judge Bondi that I said hello.
All right, thanks, Judge.
All right, thank you. You should be able to join. There you go. All right, Mr. Rognus is here. He had a 2 o'clock matter.
Thank you, Fozzie. Thank you. That's neat. I'm still trying to get used to seeing that stuff go through there, but I absolutely. Yeah, I fought with YouTube for 6 months being demonetized and kept going with it, and somehow it worked out and got monetized again. So
Correct.
it just worked. So I'm going to keep doing what I was doing, and let's see how it works out. I'm gonna get back to this one here with Judge Middleton there.
All right, this is file number 241577LT. Andrew Rognus is here on behalf of the plaintiff, and Amanda Binkley is here, and Kelly Vance is here from the company. We determined that rent was $3640.29, and we added $950 for November. And the amount was $4,005. I can't read my own writing. $4,890.
29. That's actually not due until the 10th, Your Honor. And we had emailed over a proposed conditional dismissal. I don't know if the court had an opportunity.
I have it in front of me. So Ms. Binkley, it says that you agree that the rent due is $3,390 through November 9th. Court costs are $250. The total due is $3,640. You will pay November's rent of $950 when due on 11/10. That then you will continue to try to work this matter out. The action is dismissed, but it may proceed without notice to the defendant or further process. Party specifically waive notice under the court rule. The action will be reinstated on plaintiff's submission of an affidavit of default, including entry of a money judgment if eligible, and an order of eviction which would enter simultaneously without notice of the process.
So looking at, thank you, Fozzie, so much for gifting the memberships. I was worried about that because, like, you know, I mentioned earlier, having so many subscribers, you know, most of them are just fly by night. Most of them, you know, clicked on it and, never come back to the channel. And so I was worried about gifting memberships because, you want them to go to people that show up. And so you got Donald Westerdale, you got Nancy, Bodie, Terry, Kim, Idaho Wiggles. So I guess there is a little bit of logic behind what YouTube does. I guess it does show up. Yep, we got Linus, Jay, Nan. So everybody get a hold of Jay. Tell her to call me. Tell her to call me. I feel like seems like that's pretty awesome. That's pretty awesome there. I wonder what the American flags are after everything. I wonder if that's I think that's something I put in there whenever I first thought I was going to get to be a monetized channel. I put that in. And so y'all got to help me figure out some of these little stickers and all that stuff that you're supposed to get and what y'all want for the memberships. Cause in the end, I don't know. I don't know what's on there. Brecken, you're going to be in the next round. How about this, Brecken? Today, the trophy you won was you did not get timed out or a comment deleted in Judge Fleischer's court. So you were able to make it through today there. So yep. So you handled it well today in Judge Fleischer's court, Brecken. So congratulations. So all right. Well, that's Brecken, we'll work on that. I'll figure it out for you. We'll work on it. And so yep, that works. Thank you so much. Yeah, figure out the perks that y'all want, because in the end, I don't understand how a lot of that works. So y'all got to teach me how to run YouTube. So y'all teach me how to do YouTube, and we'll fix it up for you.
So under this, you simply have to pay November's rent by November 10th. And then there's going to be some sort of workout to pay the balance.
Yeah, I mean, technically, she's got to pay the remaining $36.40 by the 15th, but Matt is aware that he doesn't need to get his writ. Well, I think the 15th is a Friday. Doesn't need to get his writ on the 18th. He's willing to do, to make some effort to work with Ms. Binkley to try to get the arrearage caught up. Apparently that's happened in the past, and he's willing to try to work with her again in that regard.
Ms. Binkley, so do you agree to pay $950 of November's rent by November 10th?
I can try. I was under the impression that because I just started my job today, to get help through DHS, I thought I had to be able to have at least one check stub under my belt to be able to show them to get help. Does that make sense?
Yes, it does.
So that's the only reason that I was asking him if he could give me a couple weeks to get, because I only get paid every 2 weeks here. So when I do get my first check stub, then I can turn that into DHS, and then they can help me, because I already tried to apply the first time and they said without a check stub they couldn't. So
where are you working?
Sturgis Library.
Well, it's pretty tenuous. They're already almost $5,000 behind in your rent. All they really want you to do is pay November's rent and work out the rest. And you're saying you can't not even sure you can pay November's.
I mean, I can try to see if I can borrow some money somewhere, but today's my first day on the job, so I haven't worked since last May, so I don't know how. I mean, it's even with three.
Right, well, absent that, absent this order, I would tell you that you have 10 days from today, which would be November 14th, to pay that amount or move out. Okay. So in this matter, they're willing to do a conditional order of dismissal under the condition that you pay that. If you don't, they could ask for a writ of eviction after. But what they're professing, they're actually giving it till the 5th. They can't take any action till the 15th of November. This depends on the goodwill and cooperation between you and your landlord to try to get caught up on their rent. Also, I don't know how much DHS is going to give you. Let's say they give you.
No, either. I've never had to go through them to have them pay anything for
Well,
me.
they,
So
for
I
one
don't-
thing, they don't have very much money.
Yeah.
So let's say they give you $2,000.
Mhm.
You're still liable for the balance.
Right.
And there needs to be some sort of plan to get caught up on
Right.
that. Now, maybe they'll pay the whole thing. I don't know. During COVID, there was lots of federal money available. They just whipped straw into gold and had a lot of money to pay people's rent. That's all basically exhausted itself. And now they have a couple of small funds of money from other sources, DHS, Community Action Agency, and Neighborhood Inc. And right now, none of them have much funding. But by this agreement, you would agree that you will do this, the matter will be dismissed. If it is not complied with, they can ask for a immediate writ. Now, this is a consent order, and as such, you have 4 business days to move to set this consent aside if you didn't understand it or it was forced upon you. But may I show that you agreed to these conditions on the record?
Yeah, it says, so I have to pay how much by what date?
It says on its face, you have to pay November's rent of $950 by November 10th.
By the 10th? Okay.
Yes.
Okay.
And Mr. Agnes, you agree with those terms and conditions?
Yes, sir, Your Honor.
I'll note that also. Now, even if you don't pay it by the 10th, your landlord can still agree to work with you. But that's the condition on there, which will give you some flexibility to try to get your rent caught up. And you can share this document with DHS.
Right. Okay.
All right. I've signed it. The rent is $3,390. Court costs are $250. So the amount due through November 9th is $3,640. On the 10th, that $900 and $950 is due. All right, you can share this immediately with DHS. Hopefully they will be willing to give you some assistance. Then you can work with your landlord to try to.
Okay, thank you.
All right, thank you. You're all good to go.
You see that one case did not get authorized, so there are no, I think, arraignments or pretrials tomorrow?
I thought I had one.
Might be
Miss
City of Sturgis.
Ms. Vance, I'll let you go.
Thank you.
And Ms. Binkley, I'll let you go.
Yeah.
Hey, Micah.
November 10th.
Yeah, that's a horrible thing with Apple products. Apple doesn't like Google. Google doesn't like Apple, and so Google makes it difficult for Apple, and Apple makes it difficult for YouTube. So it's kind of a pain in the ass. I'm sorry about that. But is that where you keep the? Yep. So we got one more Judge Middleton, and then we're going to get over to Court Addict with ATX Alley. Thank you all for the memberships, and thank you all for that. That type of support is really awesome. It's certainly not why we're doing it. My goal is to make money fighting YouTube, not make money from people. So, but it's awesome to see that type of support. It's really odd. Rivette, me too. I love Apple. I've got a PC computer, and I rarely use it. So it's I use the Apple for almost everything. But in any case, we're going to jump over to one more Judge Middleton, and then we're going to get over to Court Addict. Make sure to go check it out. We've got some good ones on there tonight, and it's going to be neat. Bodie's giving Brecken a chance to delete a message, so you have fun with it, Brecken.
Good morning, sir. Are you Gary Lee McKenzie?
I am.
I'm Judge Middleton. I'm here today covering things. Also with me is Mr. Larry Westcomb from the Public Defender's Office. You got picked up on an old warrant.
Correct.
It's alleged that on or about September 5th of 2022, that you damaged some valve stems on some tires that belonged to another person. Let me take it to the actual thing. That person is Victor Reidenauer III. It's alleged that you injured some tire valve stems that he replaced from a junkyard at the cost of $117. So they charged you with misdemeanor malicious destruction of property under $200. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Mr. Westcomb is here from the Public Defender's Office, but let me ask, how do you wish to plead to that charge?
Well, not guilty, but there's a story with it.
All right, well, we'll save that for a minute. He alleges that you put an obscene note on his window, cut his tires over some previous dispute. Amazingly, the sheriff's department seized some of this evidence and sent it to the crime lab after they got a DNA sample from you, and the crime lab matched your DNA to some of this evidence. So that took months and months and months. It didn't come back until June 20th of 2023. So apparently your DNA is on some of the evidence. So they issued the warrant in July of 2023. And here we are in November of 2024. How did you get arrested?
I got picked up by a DNR officer for trespassing.
Last night?
Yeah, Friday.
All right.
But I was hoping that I could get a PR bond on this because I've got some other stuff in Indiana I need to get taken
Yeah,
care
you
of.
got a charge in Noble County, Indiana. Tell me about that.
Well, I got pulled over. I borrowed a guy's coat. I got pulled over and there was paraphernalia.
Well, just tell me what the, so is this some sort of a drug charge?
Yes.
So he literally pulled a big one. Those aren't my pants. He said he borrowed someone's coat and got pulled over and had drugs in it. And he borrowed someone. Yes, Kim, this judge is in Centerville, Michigan. Centerville, Michigan is like the smallest town in Michigan, little town. It was referred to as Mayberry by the attorney the other day. So it's a quiet little town. And so, all right, let's finish this one up so we can get over to court attic.
Yeah, that's quite common. I borrowed somebody else's coat. But anyway, you have a hold on you from there. This thing originally had $100 bond. As I said, they do have some sort of DNA match to some of the evidence. But it's not the crime of the century, and it's almost a year and a half old.
Well, and then Victor,
in fact, it's two years old. All right, I'm going to give you a PR bond. I'm going to show a plea of not guilty.
Thank you.
I'm going to appoint an attorney and set an attorney pretrial for December 6th.
Okay.
At 8:30. Now that presumes that you'll be bonded out of Noble County by then. What was the drug in the coat? Methamphetamine or some sort of opioid?
Yeah, it was some kind of a pipe or something.
All right.
There was no drug itself. There was a pipe that was dirty or something.
All right. Well, I'll let you go down there and sort that out. All right. I'm going to appoint an attorney, set a pretrial for December 6th, 2024. The bond is $100 cash or surety. I'm just going to reduce the bond to $100 PR. You got arrested on Friday, November 1st. So 1, 2, 3, been in jail 3 days at this point.
So yeah, I need to get down to Indiana and take care of that.
Do you still live on Forest Street in Sturgis?
Yes, sir, I do.
All right. Are you going to have some sort of DNR trespass charge? You don't know yet.
Don't know yet. They said they would contact me if it would went any further.
Where was that? Here in St. Joe County?
Yeah.
All right, $100 PR bond. I've set a attorney pretrial for December 6th. We're going to give you the paperwork regarding your attorney's name and number. I want you to call that attorney, make an appointment to discuss that with them. Hopefully, if it's just a pipe in Noble County, you can go down there and deal with that and be out by the time of your hearing on December 6th. All right, sir, you're good to go.
Okay, thank you.
Thank you.
All right, I don't think we got time for the next one. I think we are going to run over to American Courts 2 with Court Addict with ATX Alley. Hey, Debbie Davis did win. She ran unopposed. Once she won the primary, it was all over from there. So she will be the new DA, probably starting at the beginning of the year. I'm not sure what they do in Michigan, but congratulations to Debbie Davis. I think that's about the only election news I really want to talk about is congratulations to Debbie Davis. I think that's the only one that really matters to me. So we're just going to call it there. Today's been a pretty quiet day in our country, so we handled the election correctly. Judge Fleischer was off today. Everybody hounded Victoria and asked her why. I don't know why. I didn't ask why. Not my business why. But we're going to go ahead and close up shop, and we're going to go over to Court Addict. We got some really good ones tonight. We got some educational videos. I looked at some videos on how fentanyl works and how that stuff works, and then some more stuff about the craziness, the the zombie drugs and stuff, and it's pretty scary. It's pretty scary. ATX keeps thinking she runs this channel too. It's the other channel she runs. So we're gonna go over there and let's see how we get over there.